From what I understand, this injunction on this has it stopped DACA, the Deferred Action of Childhood Arrivals, as well as DAPA, the Deferred Action of the parents of these arrivals as well. And this basically, it upheld what the previous court ruling. This is the second ruling in this. And what effect is this going to have on the president's desire for this executive amnesty?
Well, I think you characterize it very well. It's going to stop it from going into effect until we get to try the whole case on the merits. So we'll see what the administration does, whether they pursue this further, if they try to take it to the Supreme Court, or maybe they try to get the whole Fifth Circuit to hear it. But at this point, their whole executive action is stopped until we actually have the trial.
And they had originally, and correct me if I'm wrong on this, Attorney General, but didn't the White House originally say, okay, well, we'll go ahead and we'll halt these programs just in Texas? But there were a lot of people, yourself included, myself included, a lot of people that had problems from this. What is your take on that from the legal perspective?
Actually, the administration had told the court and all of the plaintiffs, by the way, plaintiffs being Texas and 25 other states, that they had not implemented any of these new laws, and unfortunately, we found that in March that wasn't true. They'd actually implemented in over 108,000 cases, and so that's another issue we're dealing with right now at the district court level as to how that's going to play out.
Yeah, well, and 25 other states too. This was more. I mean, these are a lot of states here that were saying, look, we need to have a little bit of uniformity. It's kind of hard to say, well, we're going to go ahead and halt this in Texas, but we'll go ahead and have this go in these other 25 states. So, what's the next option that the administration has? I mean, do you foresee this being before the Supreme Court?
You know what? There's a possibility that they'll appeal the initial preliminary injunction to the Supreme Court. If they do that, we'll take the Supreme Court. We'll make the same arguments we made at the Fifth Circuit and in the district court. But then after that part is over, then we'll actually have the trial on the merits of our case and figure out whether this is going to be permanently stopped.
Right. And I think now with these two court decisions on this, that this is probably a clear indication of where the legal opinion on this is going to go. I mean, if this goes before the Supreme Court, considering the opinions that have already been written, I feel confident. How do you feel? Because you've obviously been handling this case. How do you feel on that?
I feel very, very confident. First of all, we're right on the law. We're right on the Constitution. We're right on federal law. But also at the district court level, in order to get a preliminary injunction, you have to show two things. One is irreparable harm, and two, that you're likely to win on the merits. So you're likely to actually win the case when it actually goes to trial. And so that was determined by the district court to be true, and it was also upheld at the circuit. So, I feel confident about where we are in the judicial process, but I also feel very confident about our case.